Just talk a little bit about today, how you felt today when I know we're still kind of waiting to see exactly what happens next.
I'm grateful that the Supreme Court heard our case, but really for me nothing has changed. I'm fully supportive of Initiative 42, and I hope that all the voters across Mississippi will see the importance of supporting this initiative so that we can once and for all fully fund public education for all of our children and get out of the bottom.
For those that have not been following along, recap for them, if you will, just exactly why it was that you decided to file that initial legal objection.
I'll let Jim answer
You
that.
want me to answer that? All of this is about the ballot title that is going to explain to the voter what these measures are all about. And what you heard today, and it's an incredible position, if you cut through everything, what the lieutenant governor and the speaker was trying to do in this whole process was to have a different standard for the ballot title that goes with the initiative versus the ballot title that goes with their alternative. If you remember what was said in there is a judicial review for someone who is dissatisfied. They admit it on the initiative ballot title, but they do not want a judicial review of the ballot title for the alternative. Now, why would that be? If the Attorney General came out with something that was totally off the wall, they're even saying they would have no way to challenge the Attorney General on the ballot title that they accepted, that he proposed for the alternative. That doesn't make sense. The reason they don't want there to be a review of it is because they liked what the Attorney General did. Now, one of the questions that was asked, and if you remember, they asked the Attorney General, did they have any discussions with the legislature? Well, if you think for one moment that the Attorney General did that in a vacuum without having any discussions with the Lieutenant Governor or the Speaker, then I think you need to re-examine your position. Obviously, they had input on that. The Attorney General had to talk to them in order to not be impartial or to be partial. In other words, to try to be impartial. He wanted to know and get their input. So certainly the legislature had a lot of input to this. But you can't tell me the legislature would never want to intervene if the Attorney General came out with a ballot title that was totally wrong and misleading. But that's exactly what they argued in there. And I can't believe that they would take a position like that at the risk of a voter not understanding what the measure is all about. But as we have known from the very beginning, they don't want the voter to know what the measure is all about. I think that's the bottom line. And that's why we appealed it. That's exactly why we appealed it. And Shipman was willing to step forward and say, enough is enough.
So, Adrian, all along for you, as we heard so many others say, you just felt like it would be too confusing for voters.
It would be entirely too confusing for voters, and we want voters to understand that this is very simple. You're either voting to fully fund education or you're not.
Anything else y'all would like to add?
How do you think
Thank you for being here.
how do you think the justices received your argument today?
Well, they're all very smart people. They have a lot to think through. They asked some very, very good questions, questions that we did anticipate. They're not easy answers for everything because obviously we understand that any piece of legislation can possibly be improved upon. But the issue today to us was very simplistic. Was the circuit court's action, did it comply with the statute? And we believe that it did. Was it appealable? No, we don't think it was appealable. And the language of that statute is clear that it's not appealable. And one of the real reasons it's not appealable is because you can see today, even with as fast as this review is, we're running out of time. And if it were appealable under the normal rules of civil procedure, this thing could be delayed for months or even a year or so. And anybody could defeat an initiative if it were appealable.
Seems like at least a couple of the justices were talking about maybe going beyond the issue that I thought y'all were here today about. It was just talking about looking at both ballot titles.
Oh, that's true because our ballot title was challenged and approved. It's over with. That's not even the question.
Well, they were talking about, they're at least...
Sure. Well, they were trying to tell the legislature, I think in a subtle way, you could do a better job of writing your statute. Now, I'm not going to speak for the legislature, for the Supreme Court on that, but I thought they did a very, very good job today of getting to the crux of the issue. I really do.
One thing that came up time and again was the fact that it's difficult to write a ballot title that sums everything up in 20 words.
Absolutely, no question about it. And so that's why you have to indicate the essential differences as clearly as possible. That language is in the statute. Why they selected 20 words, who knows? If it were 40 or 50, I guess it would. The thinking would be that'd be so convoluted that it would be really confusing. So one thing for sure, you got to be as succinct as possible.
Do you think it's possible to kind of break these two arguments down into 20 words or less?
Well, that's not what the statute requires. The statute requires a ballot title in 22 words or less, or 20 words or less, that describes is a fair and impartial statement of the purpose of the measure. You heard all that argument. So, can you distinguish every single difference in 20 words or less? I don't know if you can or not, but I do know that if you put the ballot titles in there that are similar, such as that free public, for example, that's in both, so it doesn't really matter. I mean, that is not a distinction between the two measures. So once you put that ballot title in there, with the substantial differences, I think you've met the essence of the statute, and that's what Judge Kidd did. I think there's no question that the key difference is that that Measure 42 provides a specific judicial remedy, and 42A ignores that. They do not provide for any judicial remedy, but yet they put in their ballot title without judicial enforcement, which implies that no court would ever oversee that. Well, we know that's not the law. The court said that this morning. So that's why we said that theirs was wrong. It was confusing. And that's why we asked them, that's why we challenged it. Anything else?